Hey there, Tony DeWitt here. I'm a retired Missouri attorney now living my best life on a beach in Florida. I offer content and commentary on current events in the law as well as some general legal topics, but I do not dispense legal advice by video. With that understanding out of the way, here's what we're discussing today. There's an old aphorism that says even a dog knows the difference between being tripped over and being kicked. In my life, I have seen a lot of women who knew the difference between a man giving them a ham handed compliment and someone saying something disgusting and suggestive. The former, they have usually dealt with by explaining that they thought was nice but inappropriate given the situation. The latter, they've either dealt with directly or, in some cases, they've filed a complaint about harassment. Since most women are reasonable people, I have generally believed women who said they've been harassed. I think most of us do. Therein lies the problem in this case of lawyers behaving badly. All of this background to get to the story in the case about a lawyer obsessed with climbing the ladder and apparently deeply unhappy. Her name, as reported in the opinion, is Eugene Choy. As the opinion from the Supreme Court of Colorado recites, though respondent was initially hired as a county court prosecutor, she enjoyed a rapid ascent through the ranks of the DA's office. She was promoted to the behavioral health unit in March of 2020, elevated to a felony district court docket in December of 2020, and finally moved in March of 2022 to the felony violence unit or family violence unit, which she viewed as an elite unit. As a deputy district attorney with the FBU, she handled felony level domestic violence and child abuse cases. Respondent's job as a prosecutor was her life. She constantly worked, she said, and her social network consisted mostly of her coworkers. Family was the reason why I worked so hard, she said. As she explained, her prosecutorial role was a source of pride for her parents, perhaps because it signified that they had accessed a little bit of the American dream. But respondent felt that being one of the only female American Asian prosecutors in the state was isolating and wearing. She befriended and confided with Bilal Aziz, another Asian American prosecutor who had immigrated to the United States with his family, and together they often commiserated about the challenges inherent in their situation. Poor dear, constantly promoted, given lots of responsibility, a good salary, lots of authority. She was absolutely miserable, apparently. While cops usually provide the bulk of investigation for a prosecutor, most offices also employ their own investigators, usually to collect subpoenaed documents, interview fact witnesses, and help prepare witnesses for trial. The DA's office where this prosecutor worked had one such man, a fellow by the name of Daniel Hines. Choi alleged that Hines made a harassing remark to her in June of 2021. She told a coworker, doubtless knowing that this coworker would run screaming to HR with her hair on fire, about a remark that is nowhere reported in the Supreme Court's opinion. For all we know, he might have said something like, "Your hair looks nice today," and she read things into an objectively true statement. At any rate, the front office, also known as the chief of staff of the elected DA, contacted Choi and confirmed the remark, but she refused to identify who made it. She insisted she didn't want the office to take action. The chief of staff felt obligated to do something, so she called an all-office assembly and spoke to them about harassment, among other things. 2 days before that training, according to Choi, Hines sent her a text message that she believed constituted harassment. Then in August, a month after the training and 2 months after the first supposedly harassing remark, she filed a complaint with the front office, and according to Choi, she did this because she learned that Hines would be in the sister courtroom and she didn't want to work near him. Let me do a fourth wall break here and explain that in spite of what sounds like a bunch of mean girls in high school, we are actually talking about people who made it through high school, college, and 3 years of law school and passed the bar. Amazing. In spite of Hines's language not objectively constituting harassment, and in spite of Choi's supposed preference that he not be disciplined, Timothy Garner, who investigated Choi's claims, issued a letter of reprimand to Hines telling him to be more aware of his language in the future. Clearly, the prosecutor's office there was committed to the rule of due process. But even though they issued the letter, the front office testified that they just didn't have anything and closed the investigation as unsubstantiated. Imagine that, getting a letter of reprimand for an unsubstantiated claim. As frequently happens in a large office environment, Hines had his supporters and Choy had hers. Choy complained that people were talking about her, and the front office told her that they couldn't stop people from talking about her. Now, at this point, you probably think I'm really being unfair. This woman was harassed, or at least perceived harassment, and maybe you think the investigation wasn't done right, or that the woman was actually getting these awful text messages from Hines. But what follows will dispel any doubts about who the pot stirrer was here and what happened. Again, according to the opinion. On the evening of October 14th, 2022, respondent joined three fellow deputy attorneys, Mary Crenson, Danny Worrell, and Meredith D'Angelo, for happy hour at Fire Restaurant and Lounge in downtown Denver. According to Crenson, the atmosphere was fun and the mood was normal. Crenson testified that respondent did not drink much that night, nor did Crenson observe respondent sending or receiving texts. At some point, however, respondent left the table for a while, and Crenson could see respondent pacing by an elevator bank and speaking on her phone. The same evening, respondent was also exchanging texts with Chief Deputy District Attorney Daniel Cohen, one of her immediate supervisors in the FVU. Respondent considered Cohen a trusted mentor and a friendly coworker. At 6:27 p.m., respondent texted Cohen, "I also wanted to share a disgusting text that I got from a person in our office." Cohen asked about the text and respondent replied, retaliation, potentially a drunk text. I don't know. Cohen promptly asked respondent to send him the text, but respondent demurred. Well, I can, but you know who it is. After involving her supervisor, she proceeded to show everyone at the table her text message, which said, "Eugene, please stop talking about what I didn't do to our colleagues. You are using your looks against innocent people. If you want to act like all, get a sugar daddy. Fine, but that will not be me." She later sent Cohen another text, this time a screenshot of the message that purported to say, "Don't be stupid." She never told Cohen it was Hines, but she did tell other people she worked with, and she sent screenshots of both messages to them. The next day, she sent Cohen a text she claims was from Hines that contained an apology of sorts. These texts created a snowball effect within the DA's office, wanting blood from this supposed abuser. Because it snowballed out of her control, Choi likely realized that the texts would have to be downloaded and forensically analyzed, and that as a result, she might have to produce them. She kept telling people she didn't want to pursue it, and she refused to go to meetings about it. Something took on the odor of mendacity at this point. The front office wanted to meet with Choi. She ducked the meeting twice. Then she was given an ultimatum to show up. She was given that ultimatum after some of the times in the texts didn't square with what she had said previously. In the meantime, the investigative machinery landed with full force on Hines. From the opinion. Also, on October 18, Garner approached Hines with printouts of the text messages. Hines, who was visibly upset, emphatically denied sending the texts and demanded to undergo a polygraph immediately. He also offered his iPhone to Garner for inspection. Garner did not find any of the texts on his device. Hines further volunteered to provide his cell phone records. With Garner standing behind him, Hines logged on to his Verizon account and downloaded his cellular data logs. Garner testified that the cellular records showed Hines did not send an SMS text on October 15th at 2:07. Further, the data records suggested that Hines was not using data on October 14th, when respondent received the three iMessages. According to Garner, he searched Hines' records to determine if data were used to send 3 iMessages, but Hines' closest data connection entries were logged on October 16th at 6:50 p.m. and at 11:29 p.m. Hines also consented to have the DA's office extract from his iPhone all messages and other underlying data on the device showing any communication between his and respondents' numbers. On Wednesday, October 19th, Garner gave Hines' phone to Adam Bechtold, a digital technician with the DA's office, to perform the extraction. Bechtold testified that the extraction of the Hines phone turned up just 2 relevant artifacts: respondent's Google Duo contact information and 2, her phone number, which Hines added to his contacts on February 21, 2020, and which he blocked on June 18, 2020. Bechtold found no evidence of any SMS texts or iMessages between Hines and respondent. Hines is not only claiming innocence here, he's also giving up his phone and downloading his cell phone records to demonstrate he didn't do any of these things. Choy, on the other hand, ducked the meeting until she couldn't, then brought in her phone with the messages deleted. So the investigator asked to digitally examine Choy's phone, and she agreed, having deleted the message, but said she'd saved the messages on her MacBook. She volunteered to bring that to him the next day. But Choy needed allies. That same afternoon, on October 21st, 3 of Choy's defenders gathered in an office. The group discussed Choy's situation and concluded that it was inappropriate for Garner to have requested to forensically examine her phone, because these are all highly trained lawyers skilled in objective evaluation, and they were totally not trying to rescue Choy from the legal quicksand in which she was quickly sinking. When called to testify, one of these geniuses, who supposedly was very knowledgeable about digital forensics, admitted that respondent was curious about the technical capabilities of the platforms used to forensically examine cell phones. Those of you who are too young to remember the Nixon years probably also won't remember the name Rosemary Woods. Rosie was the secretary to President Nixon. She had deleted evidence from a tape that was recording conversations in the Oval Office, and it was evidentiary. Her explanation involved her stretching herself out like she was playing some game of Twister. At the time, it was roundly laughed at, and everyone knew she was lying to save her boss. We now have this issue with the young lady having been told she's going to have to bring in her phone and her computer and have them examined in order to back up her story. And she agreed to hand them over. But this is also from the opinion. Respondent testified that on Saturday, October 22nd, the following events occurred. She drew herself a bath as a stress relief measure. While the bath was filling, she placed her phone on a bathtub tray that extended across the width of the bathtub, and then left the room to get a bottle of water. When she returned to her drawn bath, she found that both the bathtub tray and her phone had fallen into the bath water. She immediately turned off the water, grabbed her phone, and dried it off, only to find that it was, imagine this, non-functional. Panicking and distraught. Yeah, right. Respondent went to her desk where she kept her work and personal laptops. She used her work laptop, which was on a riser, to call a coworker via Microsoft Teams. After speaking with the coworker, she tried to calm herself down by taking a sip of water. And then, wouldn't you know it? However, she was rattled. The open water bottle spilled out of her hands and spilled all over her desk, including her personal laptop. Her MacBook immediately went black. Aside from her alarm clock, no other electronic devices were affected. Respondent used her work laptop to set up 2 separate Apple Genius Bar appointments to repair her 2 devices. Apple's Genius Bar informed her that her trying to recover the data would be costly and unlikely to succeed. Based on that, she opted not to pursue repair of her iPhone or MacBook. Well, in spite of her quick thinking and efforts to conceal the truth, investigators found it anyway. After dodging a request to download her Verizon phone records by saying her password had been compromised, the investigators had her fix that password and come back the next day to download her Verizon records in front of them. The opinion recounts that she felt she had no choice but to do this. Well, no kidding. You accuse someone of something that is in some context a crime, and you better produce the evidence. The downloaded records showed that the text had been sent and received, but when matched against the records obtained from a download of Hines' phone, they didn't add up. So the investigators got a search warrant and got them directly from the cell provider. On Thursday, November 1, the investigator received the cell phone records. The logs confirmed that Hines never sent an SMS text message at 2:07 p.m. on October 15th. But the Verizon records differed from the logs respondent sent to Garner. The Verizon records showed that respondent both sent and received an SMS text at 2:07 on October 15th, displaying her phone number as both the sender and the recipient. The DA, of course, fired Ms. Choy. They sent her a letter. In the letter, the front office rebuked Choy for fraudulently creating text messages that appeared to be sent from Hines to her in an effort to cause him to be dismissed from employment for sexual harassment. The letter concluded this contact on your part was completely antithetical to your role as a prosecutor in the office. Well, thank you, Captain Obvious. Eventually, someone got around to reporting her to the bar, and the bar took action by holding a hearing, and this is the result of that hearing. The hearing board found that she committed at least 2 acts of dishonesty. They even noted that respondents carefully crafted testimony that the messages were from Dan Hines, as Dan Hines was saved on her phone on those dates, suggests to us that she edited her contact list for Hines or made a new contact in her phone using her own phone number and Hines's name to send the messages to herself. The board summarily rejected her defenses to the dishonesty charge, and on the charge that respondent violated the rule of professional conduct, which provides that it's a professional misconduct for a lawyer to engage in any conduct that directly, intentionally, and wrongfully harms others, and that the adversely reflects on the lawyer's fitness to practice law, they concluded that she violated the rule when she shared the counterfeit messages with the office and other coworkers. The hearing panel said, respondent not only knew she was creating false messages, but did so with conscious objectives to malign Hines. While we cannot determine by clear and convincing evidence why respondent was motivated to fabricate the text, we are certain that she acted intentionally to besmirch Hines's reputation. So, what would you think the appropriate sanction would be here? Reprimand, suspension, disbarment? Let me know what your thoughts are on this, considering that this is a woman charged with putting domestic abusers in prison. The hearing panel found that the ABA standards called for disbarment, and that was the standard that applied. They didn't feel that there were sufficient mitigating factors to reduce that sanction, and Choy was disbarred. Now, she may appeal the disbarment, and if the appeal gets filed, I will let you know. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.